Further, the section also provides that so much of such information as relates distinctly to the discovery of the object also becomes admissible, as has also been highlighted in the case of Inayatullah versus State of Maharashtra. It was a Bombay High Court case. And thus, in this case, the proximate cause, the only cause, the direct cause of the discovery of the gun in the secluded area is the part where the accused claims in his disclosure statement that after the said incident, I ran away and went to this place and threw my country made pistol there in order to, um, in fear of, and threw my country made pistol there to hide it. Thus, the relevant part of disclosure statement as enumerated above becomes admissible. Not only does it highlight the mens rea of the accused, but it also throws light on the actus reus, which will also be substantiated by our further submissions. Coming to evidence that supports, that corroborates with the with the disclosure statement, primarily would be the digital evidence which has met all the requirements under section 65p. The first digital evidence that has been adduced is that of the camera recording furnished by Mr. Gopal, who is also a point witness 3. The same, which was taken between 6 p.m. to 11:30 p.m. on the relevant day of incidents, which is 21st of September 2019, clearly shows Ashu in the vicinity of the flat. It would be pertinent to note that no other person who was related to the deceased was seen near the vicinity of the flat, and it was only Ashu who was seen. Our second submission would be that the mobile data provided by the forensic lab expert, which clearly highlights the mobile chats that happened between the deceased and the accused, clearly highlight that they were indeed having drinks at 9:30 p.m. on the day of the incident. Your Lordship and your Ladyship, it would be pertinent to know that according to the post-mortem report, the death could have occurred any time between 11 a.m. to 11 p.m. and 11 a.m. and 11 p.m. Being the absolute limits under which death could have occurred. And corroborating the same with the presence of the accused at 9:30 p.m. In the immediate presence of the deceased clearly points towards the fact that the time gap was so less that only Ashu and Ashu could have committed the said incidents. Further, and most importantly, it would be our submission that the injuries match perfectly with the descriptions provided by the accused. Sanjay died of abdomen injuries, which were done due to knife, and his mother died due to bullet injuries in the leg, and they match perfectly with the claims that the accused has made in his disclosure statement. A gun and a knife fitting the description were also retrieved during the course of evidence production, during the course of evidence collection. For the same, I would also like to bring the attention of the Honorable Court to the case of Rumi Bora Datta versus State of Assam, which was a case of the Honorable Supreme Court, where on similar facts and even the disclosure facts of disclosure statement as well as weapons of murder, a knife and a rope was retrieved, and the deceased had also died by strangulation as well as knife wounds. The reliance was placed on the disclosure statement furnished by the accused in the relevant case, and thus, in support of that, it also adds to the credibility and to the credibility of the disclosure statement and all the evidence thus alleged. Finally, it would be our submission that Ashu and only Ashu and no one else was responsible for the crime. The only reasonable suspect other than Ashu could have been Sameer, but his alibi was taken in the very initial stages of evidence collection, where he had a bulletproof alibi which clearly mentioned that he was not only not in the vicinity of the flat, but he was in Jaipur on the intervening night of the incident, and thus, due to all the evidence adduced and submissions made, it would be our humble it would be our humble prayer that the guilt of the accused has been proved beyond reasonable doubt, and thus he should be convicted of all the charges mentioned under Section 302. Permission to proceed to the arguments made under Arms Act. If there are no questions, Your Lordship, Leadership.
Yes. Did you involve anyone in the recovery of the gun?
Your Lordship.
Independent witness?
No, Your Lordship. We did not. The facts clearly say that no independent witness were present. However, the recovery was done by the investigating officer and 2 head constables.
Yes. And any liquor bottles, etc., recovered from the site?
Yes, Your Lordship. 5 black label bottles.
5.
Yes, I'm not sure as to the quantity. I believe it's 5 or 4, but yes, they were recovered.
All right. Is it mentioned in your memorials here?
Sir, which point?
About the recovery of the liquor bottles?
I believe it is, Your Lordship.
All right.
Yes, Your Lordship.
We can move on to the next point. Unless the other judges have any questions.
Yes.
Yes. If I may, sir, Mr. Jain. So, what was the nature of the camera where this where Ashu was supposed to have been seen loitering around the incident, the location, and how was it? How was that recording proved?
Yes, Your Ladyship. The nature of, for some reason, the defense has claimed that it was a CCTV recording. However, nowhere in the facts is it mentioned that it was a CCTV recording. It's only a camera recording, and in absence of any specifications provided, all the specifications pertaining to the pen drive that was retrieved are provided in the seizure memo. If I may direct the court to the same. Yes, Your Ladyship. The seizure memo dated. Just a second, Your Ladyship. Yes, the seizure memo marked as A7. The DVR number is provided, and the description of the pen drive is provided. The way it is also mentioned that it was transferred from the DVR to the pen drive. The description of the pen drive is also provided, and the relevant time of which the recording was taken is also provided, and the signature of the person who testified for the same, who also regularly used the device, is also provided, and this is also corroborated by his witness testimony as prosecution witness number 3.
I need to ask one question from you.
Yes.
It appears that you are placing your case primarily on circumstantial evidence, since there appears to be no eyewitness. So, what is the case law supporting the proposition that even in the absence of an eyewitness and when the case is completely hinging on circumstantial evidence, the courts can rely upon the circumstantial evidence and proceed further in prosecuting?
Yes, Your Lordship. For circumstantial evidence, I would like to bring the Lordship's attention to the celebrated case of Sharad Birtichand Sarda, which was a celebrated case of the Honorable Supreme Court, where it was clearly held. It was a case of 1984, where I believe it is five punch sheet of circumstantial evidence were provided, and the main inference that can be drawn from the 5 punch sheet is that the evidence should exclusively point towards the guilt of the accused, and there should be no other hypothesis that can be proved other than that of the guilt of the accused. And if it conveniences the court, I would read out all the 5 points.
You just briefly describe the 5 principles which were laid down by Supreme Court in this. That's it. For the benefit of the honorable judges. So you just give the brief description of the 5 points. That's all.
Yes, Your Lordships. In the celebrated case of Sharad Birdichan Sarda versus State of Maharashtra, the five principles as to circumstantial evidence was laid out. The first principle is that the circumstances from which the conclusion of guilt is to be drawn should be fully established. The second is that the fact should be so consistent with the hypothesis of guilt of the accused that there should be no other presumable hypothesis. The third is that the circumstances should be of a conclusive nature. The fourth is that they should exclude every possible hypothesis except the one to be proved. And the fifth is that the chain of evidence should be complete as to not leave any reasonable ground for conclusion consistent with the innocence of the accused. And that the act was done by accused in all probabilities.
So can you just sum up that uh, all the five principles are applicable in this case, or as many principles as were required to be applicable in this case are there? I mean, this case meets the five principle theory of this case.
Yes, Your Lordship, certainly. The first point is that the circumstances from which the conclusion of guilt should to be drawn is fully established. Your Honor, we would place, as we've already placed reliance on the disclosure statement, and not only the disclosure statement, but other evidence, that is medical evidence, as well as digital evidence, has also pointed that the circumstances of the night of the incidents are completely established. The second is that the facts should be so consistent with the hypothesis of the guilt that they should not be explainable on any other hypothesis. Your Lordships, it would be pertinent to note that, as we have already proved, Ashu and only Ashu could have committed the crime. No other person was proved to have been in the vicinity of the flat on the night of the incidents within such a less time gap, which is also highlighted by the post-mortem report. The third is that the circumstances should be of a conclusive nature and tendency. The Lordship's reasonable conclusion can be drawn from the facts that guilt of the accused has been proved beyond reasonable doubt and it meets all the requirements of Section 302 of the Indian Penal Code. The fourth principle is that they should exclude every possible hypothesis except the one to be proved. Your Lordships, there was no other hypothesis, and the only other even suspect that could have been named was Samir, who was the brother of the deceased. But he had provided a bulletproof alibi, and thus that point is also not sustainable. And lastly, the chain of the evidence should be complete as to not leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all probability the act must have been done by the accused. Your Lordship, the same has also been proved, as the accused not only had the motive to commit the crime, as is also highlighted by the fact that he got agitated when Sanjay showed reluctance to pay back the sum of rupees 2 lakhs, he also had the intention, as Your Lordships, he was carrying a country-made pistol to the house of his brother-in-law, and he also stabbed him with an 8-inch knife in the abdomen and shot his mother-in-law in the neck with the same country-made pistols.
All right.
If if there are no questions, I would like to seek permission to move on to my submissions related to Arms Act.
Yes, please do.
Could I? I'm really apologies. Your apologies to the bench. Could I just mention one more point pertaining to Section 302 that has been touched upon by the defense in their written pleadings? Your Lordship, the defense counsels in the written pleadings have claimed that in the written pleadings have claimed that torture was done by the police officers. Torture was inflicted upon Ashu to elicit a forced confession, and that also leads them to the conclusion that the very discovery of the gun was also planted. Your Lordships, it would be pertinent to note that they have not adduced any single circumstance which would provide towards the same, and in absence of any ulterior motive or any sort of motive on the part of the police officers or any sort of even faulty conduct on the part of the officers towards the accused clearly shows that there was no reason or no motive or no basis for them to have forcefully elicited the confession out of him. Further, we would also like to point towards the fact that when medical examination of accused is done, he is provided with the opportunity to confess to the doctor who does his medical examination in case of any aberrations that have been conducted against him. In the absence of any evidence that point towards the same, their conclusion that torture, which is a very high standard to use in this particular case, the standard of torture being inflicted on the accused clearly not having been met, this argument that the statement is not admissible because it is involuntary in nature and even the discovery of the gun is planted are clearly void and baseless and should not be taken into consideration. Thus, because in consideration of all the evidence attached and arguments advanced, it would be our humble prayer that the accused should be convicted of all the charges mentioned under Section 302 of the Indian Penal Code. I would now like to proceed to my arguments pertaining to the charges under Arms Act. Yes. Your Lordships, it would be our humble, your Lordship and your Ladyship, it would be our humble submission that the accused should be convicted of the charges under Section 27, Subclause 3 of the Indian Arms Act, Section 28 of the Indian Arms Act, and Section 29, Subclause A of the Indian Arms Act. Coming to the first section, which has two ingredients. Firstly, Section 27, Subclause 3 has two ingredients. Firstly, that death should have been committed, and that the death should have been committed by the use of a prohibited arm in contravention of Section 7 of the Indian Arms Act. Your Lordships, having already submitted that death was indeed caused by the use of the country-made pistol, which was a weapon of murder, and having fingerprints of the accused also being found on the gun, and him also having specific knowledge as to not only of the place where the gun was hidden, it would be pertinent to note that it was hidden in the secluded bushes of a park, and no reasonable man could have been expected to know that a country-made pistol of so and so description of having two live cartridges was hidden in a very secluded part, in secluded bushes of the case. And thus, this specific knowledge of the accused clearly points towards his mens rea and also clearly exhibits that he used the said country-made pistol which caused the death of the accused, of the deceased, who is Sanjay's mother. Coming to the charges under Section 28, your Lordships and your Ladyship, I would like to bring your attention to two particular phases of Section 28 of the Indian Arms Act. First is that any use whatsoever, and second is resist or prevent lawful arrest. Your Lordships, it would be pertinent to note that by placing such high um, by wording the section so loosely and using the words any use whatsoever, the legislature clearly wanted to also include cases where the accused or the accused in question would hide or use the said arms in a way that would, in a passive way, that would also amount to concealing it to prevent one's further arrest. That is why not only have they placed reliance on the words any, use, whatsoever, but they've also included the words prevent lawful arrest. Thus, it would be our humble submission that even in since the words of the sections are worded so loosely, even passive use of the gun, which amounts to concealing it in order to prevent one's lawful arrest, should also be included. And we would also like to attest a case for the same, which was Shashi Bhushan versus State of Bihar. It was a Patna High Court case where, on very similar facts, the police had filed a charge sheet under the accused, or as he was guilty of concealing arms, knowingly concealing arms, and the same accused was also convicted under the relevant section of the Arms Act. It would be our final submission that under Section 29, Subclause A, purchase, which pertains to purchasing any arms in contravention from a person who is not licensed or authorized to sell them. Your Honor, the facts clearly point toward the fact that Ashu was indeed the owner of the country-made pistol. Not only was he carrying it around with him, he hid it in a secluded area of a park for 3 months. He had the exclusive knowledge as to where the gun was exactly hidden. He also had the exclusive knowledge as to the number of live cartridges were present in the gun, and his fingerprints were also found on the said gun. Your lordships, in light of all of these facts, it's clear that Ashu was in the exclusive possession and ownership of the gun. And in this case, in absence of any other explanation for the same, the burden of proof clearly shifts towards Ashu for him to prove that the normal circumstances and observations of this particular case do not point towards the fact that he had purchased, that he was not the owner of the said country-made pistol and had not purchased it from a seller. And thus, in light of the evidence adduced and the submissions made, it would be our humble prayer that the accused be made liable of all the charges under Section 27, Subclause 3, Section 28, and Section 29, Subclause A of the Indian Arms Act. Um, if there are no questions from the bench, I would like to rest my case.
Go ahead, Mr. Dan.
Thank,
Your lordship may ask, then I will ask.
No, it's okay. I didn't have any question.
The question that I am asking is that by mere concealment of the weapon, can we say that the rigors of Section 28 of the Arms Act are attracted in this matter? Merely by concealing. You mentioned a judgment also of State of Bihar judgment. So can you make out this case as to how merely by concealing the weapon, the case of intent to resist or prevent the lawful arrest or detention of himself is made out, if you want him to be convicted under Section 28 of the Arms Act?
Yes, Your Lordships. For the convenience of the court, I would like to present a brief summary of the facts of the case of Shashi Bhushan versus State of Bihar and how they relate to the case in question. Your Lordship and Your Ladyship, in the case of Shashi Bhushan, the facts of the case were that the police got information that a person was concealing some arms in his house, and for the same. And when the police got to know of this, they stood guard outside the house and outside the vicinity of the house of the accused. And the moment the accused stepped foot out of the house, they arrested him on the charges of concealing the weapons. And the charge sheet was filed under Section 28 of the Indian Arms Act. And this conviction was also upheld by the relevant by the Honorable Patna High Court. It would also be pertinent to note that the legislature has purposefully made the ambit of the section loose by including the words any use whatsoever, and thus they have specifically widened the ambit of the said section, and that is why we can reasonably argue that preventing future lawful arrest by a passive use of a gun also qualifies as to be filed under this particular section.
All right, thank you.
With this,
I have one quick question, actually going back to the earlier part of your arguments. Are you relying entirely on the disclosure statement to establish the motive, or is there anything else to show that there was any disagreement over there was a monetary issue or there was a loan, etc.? Is there anything independent of the disclosure statement to suggest that?
I don't believe so, Your Ladyship.
You're going entirely on the disclosure statement?
Yes, Your Ladyship. Two parts of it particularly. First, that obviously the loan repayment, and second, that he was also carrying the gun around with him to the place of the accused. And yes, that would be it.
All right, thank you.
Thank you, Your Ladyship. With that, I rest my case. If there are no questions, thank you, Honorable Bench. I would request my co-counsel to begin with the further arguments.
May it please the court, my name is Harshita Mishra and I'm appearing on behalf of the state of NCT of Delhi. Over the course of next 20 minutes, I would be presenting the second issue raised in our written submission, that the accused is guilty for the charged offences under the Narcotic Drugs and Psychotropic Substances Act, which I shall hereinafter refer to as the NDPS Act. May I seek the permission of the Honourable Court to address the bench collectively as Your Honour?
Yes, please. Go ahead.
Much obliged. My first submission is that the accused is guilty under section 21 of the NDPS Act, as the illicit drugs were found from the possession of the accused, and section 21 of the Act prescribes punishment for the same. While investigating the case of murder of one Sanjay and his mother, the police found evidence inculpating the accused on the basis of the same, inculpating the accused, and on the basis of the same, the accused was apprehended on 16th December 2019 from his car, and during the search of the car, the police recovered 20 grams of white substance from the dashboard. On examination of the forensic experts, the seized article was found out to be cocaine. And therefore, the accused was in possession of the illicit articles and was in contravention to Section 8, subsection C of the NDPS Act. Prosecution has produced reliable and cogent evidence proving the seizure of cocaine from the accused. Prosecution has submitted in evidence seizure memo A11, copy of Malkhana Register A5, road certificate A9, and acknowledgement received A10, and forensic laboratory report A16 to prove the possession of cocaine by the accused. All these evidence prove beyond reasonable doubt that the accused possessed seized illicit drug cocaine. As per section 54 of the NDPS Act and the judgment of Honorable Supreme Court in Madan Lal versus State of Himachal Pradesh, once the possession is established, it can be presumed to be conscious, and the burden of proof of showing that the illicit articles were not in his conscious possession lies on the accused. We submit that the defense has not been able to discharge the burden, as the defense has not adduced any evidence in this respect. It is contended by the defense that the prosecution evidence is not reliable and the procedure followed by the investigating officer was not proper and lawful. But these contentions are totally baseless and unacceptable. First of all, it is amply evident that the investigating officer has complied with the provisions of the Act and has followed the proper procedure. During investigation, on the basis of the camera footage outside the house of the deceased and mobile chats of the accused and the deceased, the investigating officer came to know that the accused was present with the deceased just before the murder, and therefore, the investigating officer suspected the accused of having committed the offense. So he proceeded to apprehend and interrogate the accused. As per section 42 of the Act, of the NDPS Act, an officer superior to the rank of peon, sepoy, and constable is authorized to make search and seizure or arrest between sunrise and sunset without warrant or authorization. In the instant case, search of the accused and his car was conducted by the SHO, who had the authority to do so under section 42. Thus, the search and seizure has been in accordance with section 42. On the basis of camera footage and mobile chats and the recovery of cocaine from the scene of evidence, the SHO had reason to believe from personal knowledge that the accused may have cocaine in his possession. He was not required to take down such information to be taken down in writing when it is given by another person or informant. The same has been held by the Honorable Supreme Court in the case of State of Punjab versus Baldev Singh, 1999. The search, therefore, we submit that the search, seizure, and the arrest of the accused was conducted in accordance with the mandatory provision of Section 42 of the Act. The defense in the written submission has very forcefully contended that Section 50 of the Act has not been complied with, but this contention also has no force. Section 50 is applicable only in case of search of person of the accused. And it specifically states that only if the accused requires, then the accused will be taken to a gazetted officer or magistrate for the search. The same has also been held by a constitution bench in the case of State of Punjab versus Baldev Singh in 1999. And thus, the investigating authority is under an obligation to inform the accused of his right under this section. In the instant case, the SHO fulfilled the obligation as a notice was served upon the accused informing him of his legal right, and the accused chose not to be searched in the presence of a gazetted officer or magistrate. And he even gave this in writing. As such, there is due compliance of Section 50 of the NDPS Act. Further, it has also been argued that the prosecution case cannot be relied upon since there are no independent witnesses. But this argument is also not tenable. In a cadena of judgments, it has been laid down that the prosecution case cannot be doubted for lack of independent witnesses when there is nothing on record, when there is nothing to doubt the police witnesses. The case of the prosecution cannot be thrown away simply because no public witness has joined at the time of the recovery, and that police officers were the sole witnesses of the recovery. This has been laid down in many cases, but I'll be citing Ram Swaroop versus State of Delhi in 2013 and Vinod Sharma versus State of Delhi 2016. Even if, for the sake of argument, we consider the non-joining of independent witnesses as a lacuna in the prosecution case, then at the most, it may amount to a mere irregularity, as has been held by the Honorable Supreme Court in State of Punjab versus Balbir Singh, 1994. It is my humble submission that lack of independent witnesses does not affect the instant case because there is nothing. First, because there is nothing on record to show that there's a doubt in the reliability of the police witnesses. And second, no prejudice has been caused because of the lack of independent witnesses in the instant case. The defense also pointed out in their written submissions that the standing order of the government requires the minimum quantity to be drawn for chemical tests should not be less than 5 grams. This cannot be considered a loophole in the instant case, as even the samples of 2 grams each were tested in the chemistry department and found out to be cocaine as per the report of the forensic laboratory A16. Not just the samples, but the remaining quantity of seized article was sent and tested and found out to be cocaine. In fact, according to a guideline by NICFS, it was said that even a sample of less than 5 grams can be sent. The defense has also relied on this guideline. Moreover, the standing order does not confer legal obligation on the officers. And the same has been held in Noor versus State of Punjab. Further, we also submit that the defense has taken a vague and baseless defense of the prosecution case being fake and of false implication. In this respect, it may be pointed out that the prosecution evidence is reliable and cogent. Moreover, the IO and it has not been shown that the IO and the departmental witnesses had any motive for falsely implicating the accused. Therefore, there is no reason to disbelieve the police witnesses. Thus, the aforementioned contention is totally untenable. Therefore, we submit that the accused was in possession of cocaine and committed an offense under Section 8, subsection C of the Act, and is punishable under Section 21 of the NDPS Act. May I seek permission of the Honorable Court to move to my next submission?
Before you do that, you just mentioned that the SHO had personal knowledge of possession. On what basis did he have this personal knowledge?
Your Honor, the SHO was the investigating officer in the case of murder. When he found out the camera footage and the mobile chats between the accused and the deceased. He had reasonable apprehension that the accused might be involved in the case of murder. Moreover, from the crime spot, from the murders, from the flat of Sanjay, cocaine was found. Therefore, he had belief that the accused might be liable in some provision in under the NDPS Act. Therefore, he had some personal knowledge.
Where is the, in your memorial, where is it mentioned that cocaine was found in the flat? Which page?
Uh, Your Honor, I'll point to the page number in the Moot proposition.
Yes.
As per in page number 3, second paragraph,
Yes.
it has been said that a separate seizure was prepared for the white colored substance, which was probably cocaine. And the seizure memo, that is A3 parcel, after this was tested by the chemical department. And according to the report of the chemical department, that is A16 on page 26 of the Moot proposition, it is mentioned that it was cocaine.
I see. All right.
Yes, Your Honor. And moreover, Your Honor, the DNA of the accused was also found in the flat of the deceased. Therefore, his presence can be reasonably concluded. May I move to my next submission?
I have one question. Was there any nexus between the supply of drugs, according to you, with the, the loan that is supposed to have been given to the deceased? Was there a nexus, and did you try to investigate that? The murder, in other words, in any manner connected with the supply of drugs?
Your Honor, with respect to the loan amount, there is nothing mentioned in the Moot proposition which says that the supplying of drugs was connected to the loan amount. Therefore, we cannot assume this. And as far as murder is concerned, nexus between murder and the supply of drugs, we cannot assume this as well, because the disagreement and the fight between the deceased and the accused Ashu was on the basis of the loan amount and not on the basis of drugs. However, it is also seen that the deceased and the accused were consuming cocaine in the flat of the deceased. Therefore, I would say that there is no nexus, but the same that they were sniffing cocaine can be concluded on the basis of the disclosure statement and the presence of cocaine in the flat.
Right. Thank you.
May I move to my next submission?
Yes, please.
Your Honor, I will make submissions regarding the culpability of the accused under Section 25 and 27 of the NDPS Act. Section 25 of the NDPS Act provides for punishment for any person who is the occupier of a place and or enclosure, or uses it and permits that place or enclosure to be used for committing any of the offense under the NDPS Act. The circumstantial evidence of the camera footage, mobile chats, and presence of hair of the accused at the flat of the deceased prove that the accused was present in the flat. Cocaine was also found in the flat of the deceased, and the accused has disclosed in his statement that he and the deceased consumed cocaine in the flat. This evidence is corroborated. The aforesaid evidence is corroborated by the disclosure statement of the accused. It is submitted that because the accused was present in the flat of the deceased, he must be considered an occupier of the flat, and being the occupier of the flat, he did not object to consumption of illicit articles. by the deceased by the deceased Sanjay. And in fact, he was the one who supplied those drugs, and he himself also consumed the drugs. It is proved that cocaine was found in the flat of the deceased and also from the possession of the accused. There is no evidence that the cocaine in the car was kept for supplying to any other person. Therefore, the only reasonable probability is that the cocaine was kept in the flat and car for consumption by the accused. Thus, we may reasonably conclude that the accused consumed cocaine. The contention by the defense that the disclosure statement of the accused was obtained by coercion is baseless. The defense has relied upon the injury of upon the red bruise found on the inner thigh of the accused as proof of coercion. It is not tenable because I would like to point out that there is no mention in the medical report A14 that the accused had complained to the doctor that the injury was caused by the police. Doctor is an independent and responsible person. So if the accused had complained in this regard, then he had have recorded the fact in the report. The accused had opportunity to do so, but he didn't. There is nothing on record that the accused complained about any coercion before the court also. The alleged...
With permission of your lordship, I would like to interrupt. 45 minutes for the team 550 is completed, and your lordships may extend the time till maximum 10 minutes more.
May I seek the permission for an extension?
Yes, please. Go ahead.
So there is nothing on record that the accused complained before the court about any coercion. The alleged injury is on the inner side of the thigh, so it is not probable that it may have resulted because of any external violence. It may be self-inflicted, or the accused might have gotten it during some other activity or something. Moreover, in medical report A14, it is not mentioned that how old is the injury. So it cannot be said that the injury has been caused during the police custody. Thus, the accused is guilty. On the basis of the above arguments, I would like to submit that the accused is guilty under section 25 and 27 of the NDPS Act. With your honor's permission, I would like to move to my next submission.
Before you move to your next, sorry.
Yes,
May I ask a question, your lordship?
Yes, please do. Please do.
Yes. Before you move to your next submission, please come to section 25. Section 25 makes it mandatory that to attract section 25, the person should be having a control or use of any house, room, enclosure, space, place, animal, or conveyance knowingly permits it to be used. So you have submitted that merely even if he is an occupier temporarily by visiting that person. Ashu was visiting Sanjay for a short while.
Yes,
a short visitor, how can he become an occupier according to you? And you also please tell the court as to what are the essential elements to attract section 25.
Your Honor, under section 25, the word occupier has been mentioned. It can be defined in terms of the person who is enjoying that particular enclosure or thing. So in this case, the accused was present in the flat, and he was a relative of the deceased. He had some sort of control over the place, and he was enjoying the flat. He was in the enjoyment of the flat. Therefore, we can say that he was the occupier of the flat.
If I may add something to that, just look at the language of 25, talks of knowingly permitting it to be used. Can you say that a visitor can permit anybody else to use? And in this case, it was the owner of the flat himself who was supposed to be consuming, consuming the drug with him. So therefore, can you say that there is no difference between a visitor and an occupier? And would you not read these words together, owner, occupier, or person having control? I think this is frozen.
Harshita, are you there?
Am I audible? I, I'm really sorry. Apologies for the same. I lost internet connection. Yes, Your Honor.
Please continue. You are audible.
Your Honor, am I audible?
Yes, you are. Ms. Divan, you were asking a question.
Yes. Did you hear the question?
No, Your Honor, I was not able to hear the question.
Okay, so section 25 uses the words knowingly permits it to be used, right? My question is, can a visitor, a fleeting visitor, even though he may consume cocaine in the premises, can he be said to knowingly permit anybody else? Who is he as a visitor to permit somebody else? And would the words owner, occupier, or someone having control of the premises not have to be read together to understand the meaning of section 25?
Yes, Your Honor. Your Honor, we are contending that the accused can be considered an occupier, and since he was a close relative of the deceased, he had some sort of control over the flat, and he could have objected to the consumption. Instead of objecting, he actively supplied the drugs and was also involved in the consumption of the drugs.
All right, we can move ahead.
Am I audible, Your Honor?
Yes, you are. Please go ahead.
My next submission is that under section 27A of the NDPS Act, any person who finances any of the activity mentioned in section 2 of the Act shall be punishable. Section 2, 8B defines illicit traffic as engaging in the production and possession, sale, purchase, etc. of the narcotic drugs. Term financing
Go ahead, please. Go ahead.
the term financing has not been defined in the Act. Therefore, we may understand the term in its general meaning as raising or providing fund or for any activity. The statement of the accused clearly shows that the accused used to supply drugs to the deceased, Sanjay. However, there is nothing on record to show that the accused took money in return for the supply of drugs. Therefore, it is obvious that supply to and possession of the drugs by the deceased was funded and financed by the accused himself. Thus, the accused used to finance the procurement, possession, and use of narcotic drugs by the deceased. Therefore, he can be held guilty. He is guilty under section 27A for for financing illicit traffic. May I seek your lordship, your honor's permission to move to my next submission?
Yes, I think please do.
In addition to the above charges, the accused is also guilty under section 28 of the NDPS Act for attempt to commit an offense under the Act. As the cocaine was found from the possession of the accused, the only natural and reasonable conclusion is that the cocaine was kept by the accused to be either consumed by himself or was for sale or for any other use. Any such purpose, any such purpose of the alleged drugs is an offense under the Act, and therefore the accused must be held guilty for the attempt to commit an offense under Section 28 of the NDPS Act. Thus, I conclude that the accused is guilty under Section 28 of the NDPS Act.
All
With your Lordship's permission, I would like to move to my prayer.
yes.
In light of the submissions made by the prosecution, it is humbly prayed that this honorable court may be pleased to hold guilty and convict the accused of charges under Section 302 of the Indian Penal Code, under Section 21, 25, 27, 27A, and 28 of the NDPS Act, and under Sections 27, 28, and 29 of the Arms Act.
Thank you.
Thank you.
Any questions, Mr. Jain, Ms. Divan? Or we proceed? Yes, we can proceed, I think. Yes. All right.
Thank you.
With your Lordship's permission, now we may proceed with the Defense Counsel's submissions.
Yes, please do.
Team 506, may please intimate the time taken by both the speakers as well as time for rebuttal.
Yes, we will do that. May it please the court, I'm the counsel for defense representing Ashu. Before we move forward, the defense would like to reserve 5 minutes for rejoinder, and the remaining 40 minutes will be divided between the two co-counsels equally. Counsel shall address the issue of murder under Section 302 of the Indian Penal Code and the charges under the Arms Act, namely Section 27, 28, and 29. My co-counsel shall address the issues under the Narcotics, Drugs, and Psychotropic Substance Act. In addressing this issue, counsel shall make two key submissions. One, that the evidence adduced by the prosecution is inadmissible. And two, the remaining evidence is not enough to prove the guilt of the accused beyond reasonable doubt. Counsel seeks permission to proceed with his submissions.
Go ahead, please.
Yes. Counsel requests your lordships and ladyship to refer to page number 2 of the memorandum. This talks about the search and seizure done by the SHO, here in this case the investigating officer, at the crime scene. The search must be done with respect to the provisions of Section 100 of the Criminal Procedure Code. As per Section 100 Clause 4, the police must make full effort in joining with independent witnesses from the locality of the place of search, and if independent witnesses are not available or refuse to join, the police must make the extra effort of going outside the locality to bring in more independent witnesses during the search. The police has not made a full effort because the police had stopped looking for independent witnesses immediately after the neighbors refused to do so. The object of having independent witnesses is to ensure that the police has conducted their search properly, has not damaged any of the seizure articles, and has not planted anything at the crime scene. And this object has not been followed. Stating this object, and the Supreme Court in the division bench at the case of Yaqub Abdul Razak Memon versus the state of Maharashtra has categorically stated that having independent witnesses is mandatory with regards to a search and seizure. Moreover, every police officer and witness who enters the crime scene must have a personal search undergone by them. This is to ensure that the police and any witness are not carrying incriminating evidence that can be planted at the crime scene. This rule has been acknowledged by the case of Yaqub versus state of Maharashtra and by the full bench in the case of state of Bihar versus Kapil Singh. The previous cases are cited in footnote number 5 and footnote number 6 of the memorandum. Moreover, there has been a delay between the receipt of the information and the arrival of the SHO. The information was received at 8:25 a.m. by the police, and the SHO had arrived at the crime scene at 9:02. This leaves a time gap in which any person could have entered the crime scene and planted the evidence. This can be seen as by the time the SHO had reached the crime scene, he had already found 8 journalists inside before he could seal the crime scene. Therefore, this shows that there's a time gap in which anybody could have entered and planted the evidence. The evidence here the defense is trying to bring attention to is the hair found at the accused at the place of incidents, which belongs to the accused, and the prosecution has used this hair to make the bench believe that the accused was present at the time of the incidents. The council, with all these procedural irregularities and the importance of this procedure, sheds doubt on the evidence, the hair found, and submits that it could have been planted. Moving forward, at page number 3 of the memorandum, uh, the admissibility of the CCTV footage mentioned by the prosecution has been discussed. In with respect to the CCTV footage, the requirements of Section 65B of the Indian Evidence Act, which is namely a certificate proving the authenticity given by the owner or controller of the primary document recording this electronic evidence, or the primary document itself must be submitted in the court of law to ensure that this CCTV footage is admissible. This has also been said in the case of Anwar versus PK Bashir by the Supreme Court. However, both these requirements have not been followed. Firstly, the primary document, which is the DVR in this case, has been reformatted as per the prosecution witness 3 Gopal's statement. Moreover, the pen drive does not have any certificate by the Gopal assessing that this record is authentic has been issued to the SHO. To shed further doubt on this evidence, as per the Malkhana register given in Annexure 5 of page number 13 of the proposition, we see that there is no entry made of this pen drive seized. The pen drive has been seized as per the seizure memo. However, there has been no entry to the Malkhana register with respect to this. This shows that the chain of custody of this evidence is not complete and gives a much higher suspicion, saying that this evidence can be tampered, that this electronic record can be tampered by the SHO or anybody who was in custody of this pen drive. Excuse me. Apologies. Moving on to page number 4 and 5, which talks about the pistol, which talks about the admissibility of the recovery of the country-made pistol, which allegedly belongs to the accused. As the prosecution has stated, has accused the defense of saying that the disclosure statement is based on coercion and this evidence is baseless. The defense would like to point the judges to page number 6 of the Moot Court proposition, which refers to the reports of ABC Hospital, which happened right after the arrest of Ashu and right before he had said the disclosure statement. He had made the disclosure statement. This report states that Ashu had no injury marks on his body whatsoever. And while we have seen this, counsel would direct the bench to refer to Annexure 14 given in page number 24 of the memorandum of the Moot proposition. Apologies. This shows the red bruises of the inner part of the right thigh, and this medical examination was conducted immediately after the Ashu had given the disclosure statement and supposedly led the police to Nehru Park, where the gun was recovered. Since looking at the proximity of this medical reports, where one says there's no injury immediately before the issue of the disclosure statement, and one says red bruises causing extreme pain immediately after the disclosure statement, the defense can conclude that the accused was harmed in police custody and was tortured. Therefore, this disclosure statement was made by coercion and under duress. Hence, this disclosure statement should be inadmissible in its entirety as per Section 24 and 26 of the Indian Evidence Act. Moreover, the prosecution has attempted to make the disclosure statement admissible as per Section 27 of the Indian Evidence Act. However, since this disclosure statement was given in duress, the defense submits that it should not be admissible. This is because the 11-judge bench of the Supreme Court in the case of State of Bombay versus Katikalu Ogad states that any disclosure statement made under duress by the police is hit by Article 20, Clause 3 of the Indian Constitution and therefore should not be admissible. Hence, defense submits that disclosure statement should be inadmissible in its entirety. Moreover, the prosecution, upon recovery of the pistol, has not proven any link between the pistol and the bullet shell found at the crime scene, thereby trying to give evidence whether that the bullet shell was used in the commission, the pistol was used in the commission of crime at all. The importance of a ballistics report states that the bullet shell found at the crime, it gives a link between the bullet shell found at the crime scene and the pistol, and thereby certifying that the pistol would have been used for the commission of this crime. However, there has been no ballistics report, and therefore it is inconclusive and erroneous to assume that this pistol has been used in the commission of the crime, thereby killing Sanjay's mother in this case. Moving forward, there has been no independent witnesses in the recovery of this alleged murder weapon. And moreover, this recovery has happened in Nehru Park, which is a public place, and there is no lack of people who can be independent witnesses for this matter. The police had not made any effort whatsoever to bring independent witnesses during this recovery to show that this recovery was proper and according to procedure, and the evidence found was not tampered. The case of Harjeet Singh versus the state of Punjab, the Supreme Court's division bench states that if there were no independent witnesses in the recovery of any arm or any evidence as per the disclosure statement, and moreover that this recovery happened in a public place, then the disclosure statement and the evidence inspires no confidence in the case of the prosecution. The defense would also like to explain the presence of Ashu's fingerprints on the pistol. The Moot proposition in page number 7, paragraph 3, categorically uses the word handed over in the case when with respect to the recovery of the pistol. This implies that the accused was made to pick up the gun found at Nehru Park and hand it over to the station house officer, thereby implanting his fingerprints on the gun. And with this evidence, prosecution is erroneously claiming that the gun was indeed in possession of the accused. With respect to all the procedural irregularities and suspicion with recovery of the pistol, for the ease of the judges, it can be concluded that Ashu was arrested, and upon duress, he had to give a disclosure statement which was concocted by the police. And upon this, he was made to go to Nehru Park with the police in the pretext of Ashu taking the police to Nehru Park, and upon finding the gun, was made to pick up the gun and give it to the SHO, thereby implanting his fingerprints on this. This concludes one of the key issues that the defense is trying to establish here. If your lordships and ladyship have any questions, the counsel will be happy to answer them.
I think you conclude, then we'll ask questions to you.
Yes, your lordship. Counsel would like to move to the next issue, which is determining the mens rea and the actus reus in commission of any of the crimes accused by the prosecution. Counsel requests the lordship and ladyship to refer to page number 8 and 9 of the memorial. This talks about the mens rea and actus reus. Before approaching this issue, counsel would like to state that he has proven that the CCTV footage, the hair found, and the pistol and disclosure statement should be held inadmissible by the court of law. Moreover, the mobile chats were only seen by the SHO. The forensic reports of these mobile chats were only seen by the station house officer. And he has come to the conclusion that the Ashu and the accused were having, the Ashu and the deceased were having drinks at 9:30 p.m. The defense has not seen these chats. The prosecution has also not seen these chats. This assertion that they were having drinks together is purely based on the SHO's interpretation of these chats and is not conclusive evidence to prove that Ashu was there at the crime scene to begin with. To add to this, we can see with the lack of evidence, there is no actus reus or no commission of offense done by the accused in this manner. Also, as per section 1.2.2 in the memorial, the prosecution has failed to establish any link between the pistol, the bullet shell, and Ashu to accuse him of the offences under the Arms Act as well. With this, prosecution shall respectfully submit that the accused must be acquitted of the charge of Section 302 of the Indian Penal Code and the charges under the Arms Act. If uh, if your lordships have any questions, the council will be happy to oblige.
Yes, first of all, have you explained your presence in the vicinity of the house of the deceased?
Your lordship, there is no proof that he was in the presence of his vicinity because the CCTV camera itself is inadmissible, and he's not in the he hasn't been seen uh, in the inside the flat as well because the hair is inadmissible as well.
Why would the prosecution try and frame you?
The defense cannot comment on the prosecution's motive in framing the accused, but the evidence definitely seems that way.
You just mentioned that you did not have the benefit of seeing the chat between the deceased and the and Ashu. Why did you, if you did not have the possession of these chats, why did you not ask for the relevant documents under section 207 of CRPC?
Your lordship, we did ask the documents from the moot court organizers, but they had on purpose omitted to add this to look into the depth of the analytical skills of the moot court contestants.
No, what I am saying is that under section 207 and 208 of the CRPC, accused has a right to have the copies of all the documents which prosecution is relying upon in the charge sheet. So today, if you are saying that the defense side did not have the benefit of a document of which only the prosecution side had the benefit, and it was only the SHO who read the chat and not the defense, then why was this issue not taken up during the course of trial, and why the documents were not asked by you if the documents were not supplied to you? That is the question.
Your lordship, the case is right now on its final arguments, and the defense doesn't believe that it has the ground to ask for these documents at this stage. Moreover, the prosecution is also relying on the SHO's assessment of these chats, and the SHO's assessment of these chats might help for the investigation, but it cannot be said as conclusive proof again that he was actually present over here. Why the chats will only benefit the SHO in the course of his investigation.
Were there any defense witnesses?
No, your ladyship.
Attempt at an alibi?
No, your ladyship. There were no defense witnesses for this. If your lordship and ladyship have any more questions, have no more questions, then my co-counsel will begin with her arguments.
With the permission of your lordships and ladyship, the council would now like to put forth the submissions against the charges laid under the NDPS Act against the accused.
Please go ahead.
The council will also be making two key submissions. First, that the investigation of the police exhibits procedural irregularity leading to an unfair trial. And second, that the prosecution has failed to prove the guilt of the accused under the NDPS Act beyond reasonable doubt. Now, the first irregularity that the council would like to point out is with respect to independent witnesses. The presence of independent witnesses as a mandatory requirement at the time of the search is conducted was stated in the case of Deepak Rana versus State of Punjab in 2019 in its para 11 and 13 of the judgment, which said that such is a mandatory requirement to ensure that the process undertaken by the investigation team is fair and just. A number of judgments from time and again have stated that having independent witnesses is an apposite requirement. On this, the prosecution case on page 12, para Roman numbers 3 of the prosecution submission state that the absence of independent witness, and I quote, strictly per se doesn't vitiate the prosecution case. The counsel for the defense makes two submissions in this regard. First, even if we take into account, even if it is taken into account that it doesn't strictly vitiate the case, it raises reasonable suspicion that the procedure was not duly followed. And secondly, that the SHO did not only fail to join such witnesses, but also failed to make an attempt to do so. Moreover, since the accused was apprehended from Vijayanagar market, which is a public place, there could have been no dearth of witnesses had the attempt been made. Now, therefore, even under section 43, which has not been discussed by the prosecution at all, the SHO should have made an attempt to join independent witnesses, and not doing so raises reasonable suspicion that the drug was in fact planted. Accordingly, it is also submitted that the sampling and packaging that was done was also not done in the presence of such search witnesses, and therefore adds to the suspicion. Now, further, as per the case of Amani Fidel Christ versus the Narcotics Central Bureau, stated in footnote number 22 of the defense memorial, duly refers and explains the ambit of the standing order 1/88 read with 1/89, which has been relied upon. In point 1.6 of the 1/88 standing order, it is stated that the minimum quantity for forensic examination should not be less than 5 grams in totality of the total quantity recovered at the time of the seizure. Now, this submission has been advanced on page 6 of the memorandum of the defense, if your lordship and ladyship would refer. In the present case, the SHO only sampled and packaged 3 packets of 2 grams each, which led to a non-examination of the said samples which has been indicated as Annex 16 colli of the Moot proposition. Now, it is submitted here that this raises a question on the very sanctity of the physical evidence that was sent to the chemistry department and spikes suspicion. As the counsel for the prosecution mentioned, that this standing order has no legal obligations. To clarify the same, even though the standing order is an executive order and imposes no legal obligation, in para 19 of the Amani Fidel case, and also in the case cited by the prosecution, Noor Aga versus State of Punjab. Even in that case, it was stated that even though there is no legal obligation, there should be at least a substantial compliance by the investigation team, which was also not done in this case. Now, further, with regard to the forensic examination, the SHO also did not adhere to the 72-hour limit for any chemical analysis of any contraband received. This is relying on the same report as cited by the prosecution, the NICFC report, which says that there's a 72-hour limit for any kind of criminal analysis. Now, this can be determined with regard to the sample that was recovered from Sanjay's house. The sample was recovered on 22nd September 2019, whereas it was only sent to the forensic laboratory on 3rd October 2019, as per the road certificates annexed as A9 with the facts of the case, which is almost 10 days after the recovery, which again raises suspicion that the investigation was a farce. Now, if your lordships and ladyship would turn to page 9, part 3 of the prosecution memorandum. In this section, the prosecution has stated, and I quote, that he confessed that he brought drugs for the deceased at his residence. Later, they consumed alcohol and sniffed cocaine. Now, here it is submitted that the prosecution is merely relying on the disclosure statement given on page 9 of the facts of the case, which is in itself inadmissible in the court of law by virtue of section 26 of the Indian Evidence Act, and as has also been previously discussed by my co-counsel. Moreover, the prosecution has failed to prove a connection between the white colored substances later confirmed to be cocaine found at the place of incidents and the accused's car. Now, if your lordships and ladyship may turn to page 7 of the defense memorandum. The postmortem report here indicates that Sanjay indicates that Sanjay, the deceased, and I quote, was highly intoxicated at the time of the incidents, but there was no toxicology test done on the same. Now, if a narcotic drug is found along with alcohol bottles at the place of incidents, as in the present case, it is contended that a toxicology test should have been done to ascertain whether the deceased was actually consuming cocaine to avoid any doubt. Similarly, if any drug or substance was found in the possession of the accused, as in the present case has been alleged, they should undergo a toxicology test, as it is a duty of the investigating team to ensure the same and make sure that there is no leaf left unturned to meet the ends of justice. Now, without the test here, there is no proof that the accused was involved in the consumption of any kind of drugs, as has been clearly stated in the prosecution submissions that the accused was involved in the consumption of drugs. If your lordships and your ladyships may refer to page 13 of the prosecution case. Now, in the first paragraph itself, it is stated that section 42 of the Act does not mandate recording of reasons for arrest or search under the NDPS Act. Apologies. Now the council begs to differ here. Section 42, subclause 2 of the Act states that where an officer takes down information in writing, he has to record his reasons and send a report of the same to his immediate superior within 72 hours. Now, whether such information was recorded in writing by the SHO or not is unclear from the facts of the case. However, even if it was not recorded under section 42(1), it is humbly submitted that under section 57 of the NDPS Act, titled Report of Arrest and Seizure, the SHO in all cases was required to record the reasons for his belief and send a copy of such a record to his immediate superior, which was also not done in the present case. Therefore, based on all these submissions, the council humbly submits that the drug was planted in the car to wrongfully frame the accused, and it is extremely important that the honorable court today should take note of these submissions and place emphasis as on this, as all penalties envisaged under the NDPS Act are enhanced in nature and may be fatal to the accused if he is falsely framed or convicted. If your lordships has any questions, the council will be obliged to answer.
You just heard the prosecution counsel to also be charging you with section 27A. Supposing we do not agree with you on your recovery submissions, etc., what do you have to say on this?
Yes, your lordship. Your lordship, even though this matter has been elaborately discussed in the second submission that the council will be making here, to briefly answer your question, the council for the defense has established that there was no real connection between the two contrabands recovered, and there is no proof on record which elucidates that the accused was actually involved in the illicit traffic of drugs. Which is dealt with under section 27A. The council will be making several submissions in this regard as well. If your lordship is pleased, the council would like to proceed with the second issue.
Oh, yes. I thought that you finished on your submissions. Go ahead, please.
Apologies. Yeah. Moving on to the second issue, the investigation conducted produces inconclusive proof of the guilt of the accused is contended by the counsel for the defense. Now, it is humbly submitted that there is no direct connection that can be drawn that links the cocaine found at the accused's car with that at Sanjay's house. Moreover, there is no substantial proof that the accused was specifically involved in the sale or purchase of any cocaine. The only fact that indicates to such a sale is the accused disclosure statement on which the prosecution has heavily relied on, which in itself is inadmissible by virtue of Section 26 of the Indian Evidence Act. Moreover, information given therein also cannot be used, such as the loan to establish motive or any consumption or sale, because any such information that is sorry, that is brought to light through the disclosure statement has to be corroborated further with evidence, which was also not done in the present case. Your Lordship and Ladyship, the Council would like to, before moving on, would like to emphasize on the very objective with which the NDPS Act was laid down. That is to control and regulate the operations of narcotic drugs and psychotropic substances. For this purpose, it is important to note here that the Act entails enhanced penalties ranging from minimum of 10 years of imprisonment to death penalty for some cases. Due to such a nature, the Act itself lays down some certain safeguards for the accused to ensure that such person is accorded with the full opportunity to be given a fair trial, which has been contented in these submissions by the Council. Now, one such safeguard provided within the Act is given under Section 50 of the Act, titled Conditions under which search of persons shall be conducted. Now, it is submitted that the police miserably failed to comply with the requirements of Section 50 of the Act. The safeguards provided under the said section has been time and again emphasized in a number of judgments by laying down that the principle laying down the principle that a failure to observe these safeguards would render the conviction illegal. Now, in the instant matter, even though the SHO apprised the accused of his legal right to be searched before a gazetted officer or a magistrate, if the accused so requires, he failed to follow the mandatory and strict compliance with the procedure as conferred under the Act. To show the non-compliance, the defense is relying on a four-step compliance process and methodology as was laid down by the Honorable Court in the case of Arif Khan versus the state of Uttarakhand, cited as footnote number 39. Now, in the present case, the SHO was required to produce the accused before a gazetted officer or a magistrate, which was not done in the present case. Although the Act states an exemption to this rule, that is, only when the SHO has sufficient reason to believe that the accused would run away with the contraband recovered, shall the SHO dispense with this requirement. But that was also not the case in the instant matter. Moreover, none of the members of the raiding team, which included the SHO and the two head constables, and no such witness, no public witness was included in the raiding team, was also not vested with the same powers as a gazetted officer or a magistrate, and therefore were not authorized officers before whom the accused could be produced and the search could be conducted. Now, in fact, the SHO was duty bound to include independent search witnesses to ensure transparency and creditworthiness, which was not done in the present case. Lastly, the case of Arif Khan also stated that even if the accused waived off his right to be searched before the gazetted officer or the magistrate, it had no bearing on the case because it had to be cumulatively looked at with respect to other evidences. Now, at the same time, even if we take into account the distinction between personal search and search of vehicle, which was also discussed by the prosecution, the SHO was required to comply with the requirements of Section 50 of the Act. This was laid down in the case of State of Rajasthan versus Parmanand and another in 2014. The Honorable Apex Court in para 12 of the judgment clarified that whenever both the personal search as well as the search of a conveyance is conducted, the SHO is obligated to comply with the said provisions. The idea is that the accused reposed faith in the SHO and therefore waived off his right in writing to be searched in the absence of a gazetted officer or a magistrate. But this in no way dispenses the officer of his duty to produce the accused before a gazetted officer or a magistrate. Therefore, the police here as well failed to do so. Now, it is humbly submitted before the Honorable Court that the accused did not have any knowledge of the drug in the car and the same was planted in his car. Moreover, mere possession of the drug which was planted cannot be construed as consumption, as there was no toxicology test done to ascertain this. Further, the law also mandates that the prosecution should prove that the accused indulge in financing directly or indirectly any of the activities within the meaning of illicit traffic of drugs as under section 2, 8B, 8A. Now, in the instant matter, there is nothing on record to show that the accused sent or gave any money whatsoever for facilitating this illicit traffic of drugs. The prosecution has contended in their submissions that the accused financed directly or indirectly the procurement of such a substance, here the cocaine, but there is no proof of the same. Now, additionally, there is also no proof to link the two contrabands found at the place of instance and the accused's car, indicating that the accused financed or even procured the drugs for both himself and the deceased, except the disclosure statement, which is again inadmissible. The prosecution case in section 4 on page 10 of their memo is again repetitively in fact relying on the inadmissible statement, making the assumption that the accused was purchasing such drugs and was a source and was procuring it from another source and supplying to Sanjay. In the absence of sufficient evidence, the accused cannot be convicted for financing the illicit traffic of drugs of cocaine under section 27A of the Act. Therefore, the council submits that the investigation is incomplete and insufficient and inconclusive, and the accused cannot be convicted as the prosecution has failed to prove the case beyond reasonable doubt. It is contended that the drug was in fact planted to wrongfully frame the accused for the offenses that he has not committed. With this, the council completes her submissions. If your lordships may have any questions, the council will be pleased to answer them.
Mr. Jain, you have any questions?
Yes, Your Lordship. You have mentioned about Arif Khan versus State of Uttarakhand, which is
Yes,
a
Your
2018 judgment.
Yes, your lordship.
In the same year, 2018, Volume 1, SCC, page 222, is the judgment of Honorable Justice Pinaki Chandra Ghosh and Justice Nariman, which is known as Krishan Chand versus State of Himachal Pradesh, which says that merely because the official witnesses were not, the testimony of official witnesses was not corroborated by independent witnesses, that does not lead the entire testimony unreliable. How do you deal with this situation? How do you overcome this position of law?
Yes, your lordship. Your lordship, even though it is stated in the judgment, as you said, that the independent witnesses are not that it can be dispensed with as public witnesses were there. The idea, the objective behind involving independent witnesses is only to ensure that there is transparency and there is no loophole, and there is no hole where the prosecution or the police could in any way tamper either with the evidence or the seized articles, and then the investigation is fair and just. Now, here in the present matter, the defense is relying on the importance of independent witnesses only to ensure that the case is fairly tried, that the accused here gets a fair opportunity, and if there is any loophole, and moreover, the counsel here submits that all the evidence that has been advanced in the defense case with respect to NDPS should be cumulatively looked at. It should not be independently looked at one thing or over the other. So with this regard, the council still submits that there is an importance of mandatory procedure of involving independent witnesses. If your lordship is pleased with that, the council would like to proceed to the prayer.
I have one question.
Yes, your lordship.
Refer to the need for a toxicology test and there
Yes,
being
your lordship.
absence of one in this case. Can you tell us the provisions of law which you are referring to and any case law on this, if you are relying on any case law to support this proposition?
Yes, Your Lordship. Your Lordship, the law that the defense is relying on is again with respect to the standing orders, where it is where sorry, apologies, not the standing order, the NICFC report, which is made, which clearly states that a blood or a urine sample has to be sent for a toxicology test in case any contraband, in case a person is being accused for consumption of drugs. And with respect to this, even though the NDPS Act clearly does not lay this provision, it has been interpreted in a number of in that particular report. So the defense here is relying on that report to come to this conclusion. And moreover, the fact that it was said that in the postmortem report that the deceased was intoxicated. Now, it is unclear. Merely stating that it was intoxication does not imply that the intoxication was based on both through the alcohol and the cocaine. So to clearly distinguish, to make sure that there is no hint of doubt that is here, the defense is here pushing for a toxicology test and arguing that there was no, so you can't differentiate whether there's actual consumption or not. If your lordship is pleased with the submission.
Any case law that you'd like to rely on?
Your lordship, the defense hasn't cited any case law with respect. We have, however, cited the NFC report.
Thank you.
Thank you, your lordship. If your lordships are pleased, the council would like to move on to the prayer for the case.
Please go ahead.
As per the issues raised, arguments advanced, and authorities cited, the defense humbly and most respectfully prays to the Honorable Court to acquit Ashu, the accused in the offences under Section 302 of the Indian Penal Code, Section 21, 25, 27, 27A, and 28 of the Narcotic Drugs and Psychotropic Substance Act, and Section 27, 28, and 29 of the Arms Act, or pass any other order that the Honorable Court deems fit, which is most humbly accepted by the defense.
All right. Thank you. Yes, any rebuttal by the prosecution?
Yes, your lordship. Permission to proceed with the rebuttals?
Yes.
Yes, your lordship. Primarily, the first argument that was made by the defense was that that the hair was planted, and that could have been done as the scene was disturbed. 2 points on that, your lordship. Primarily, that Ashu is the brother-in-law of the accused, so it would not be out of place to imagine that some third person would come and plant the hair of a brother-in-law of the deceased simply to provide evidence against him. Secondly, the police reached the place of incidents as soon as possible, as soon as they were intimidated. So journalists or any third person entering the scene to click pictures is out of control of the police, and the fault for the same should not be imputed to the police. Second, the defense keeps claiming that the standards under Section 65B have not been met, but they never enumerate as to what particular standards have not been met. As we've already discussed at length in our arguments, that all the requirements have been met. Information as to the device in which the camera recording was stored is provided. The method through which it was transferred was also provided. The specifics as to the camera recording, as to the time of the camera recording, are also provided. The person responsible for the said camera recording, who was in an official position to operate the same, has also testified as a witness, and his signatures are also present. So, in absence of any reason as to why the same should not be admitted, their claim as to Section 65B is absolutely baseless. Even if we go by the argument that the original document could not be produced, the same cannot be sustained, as the facts clearly highlight that the police had specifically asked Gopal, who is point witness 3 and also the owner of the camera, to preserve the same recording in the initial stages of the investigation. The fault that the DVR got formatted, the fault for the same cannot be imputed to the police in warrant, as even otherwise, all the requirements have clearly been met. Further, the pertaining to the claims of disclosure statement, it would be interesting to note that the defense has not provided one single argument as to the substance of section 27, which talks about discovery of fact or information related to it. The only reason which they have given for the non-admissibility for the disclosure statement is the possibility of it being coerced or the possibility of being elicited out of duress. And even this possibility has not been sufficiently explained by them, as they're only placing reliance on torture. Again, torture is a very heavy burden that is being claimed by the defense. And if they are to prove that torture was conducted, they have also not provided any sort of injury marks other than some bruises which were found on one thigh of the accused. We need to realize that the standards of torture are extremely high, and as was also enumerated in the case of A.K. Sahdev versus Ramesh Nanjisha, where it was clearly mentioned that injuries are, when it was clearly provided that the injuries were simple in nature and they do not conclusively point towards any sort of duress or coercion on the part of the police. Further, the defense has also claimed that there is no connection between the gun and because between the murder weapon, which is the gun, and the accused. It would be pertinent to note that the gun, not only did the gun have fingerprints of the accused, but the accused had specific knowledge as to where the gun was hidden, how many cartridges it had, from where it was kept for 3 long months, and thus due to this, it can be reasonably expected that the accused had specific knowledge as to the gun. And the defense has placed reliance on the fact that the gun was hidden in a public place. Your Honor, it would be pertinent to note that however the park might or might not be a public place, the place where the gun was specifically hidden was a secluded part of the same place. And it would also be pertinent to note that the discovery happened in the late hours of the evening. Since Ashi was arrested at around 4 or 5 p.m., the recovery must have happened after the recording of disclosure statement, after his medical tests were done, after the senior house officer gathered the camera recording. Thus, it can be reasonably assumed that the recovery happened in late hours, and thus no person can be reasonably presumed to be present at a secluded place of a park at that hour. Further, the defense has said that handing over means picking up a gun and giving to the police. I believe that, but that is absolutely not correct. Handing over is a phrase that is used to mean that if I hand over this pen to someone, that means I'm giving the custody of this pen to that particular person. I don't have to necessarily pick up the pen and give it to them. They can pick it up themselves. Handing over doesn't necessarily mean that I am picking up the thing and handing it over to the other person. They have completely changed the meaning of the phrase handing over, which is a metaphor, and they have taken the literal meaning of the same, which claim is absolutely baseless in the present circumstances. Further, they've also claimed that pertaining to the admissibility of mobile chats, the senior house officer is the only person who read the mobile chats. Your Lordship, the senior house officer in this case was the investigating officer. I am under the assumption that the investigating officer is the only person who generally reads the evidence and not a third person. So we don't see any reasonable conclusion coming from their claim that SHO was the only person who read the particular mobile chats. Besides, the mobile chats were furnished by the forensic laboratory expert, so there is absolutely no reason to doubt the veracity of the same. Lastly, the defense counsels have placed heavy reliance on presence of independent witnesses, and they've also referred to the prosecution memorial to refute the prosecution's point. Your Lordship, I would also like to refer to the prosecution memorial in exactly the same line which the defense has cited, and I would like to point out the line which the defense counsel cited. The defense counsel cited the second line on page. Just a second, Your Lordships. Just a second, Your Lordships. Yes, Your Lordships, the defense has placed reliance on page 13, line 2, page 12, the last second line of page 12, where they said that if there is no strict compliance of any of these instructions, this by itself cannot render the acts done by these officers null and void and invalidate the trial. But they've also referred that the case of prosecution cannot be thrown away simply because no public witness has been joined. We would also like to point out that we've also submitted that when there is nothing on record to doubt the officer's investigation, only then can the lack of an independent witness can be adduced as sufficient reason to doubt the prosecution's case. The defense counsel has been unable to provide any single reason which would point towards the fact that the investigation happened in an unfair manner, or that the prosecution or that the police witnesses are to be doubted. Further, lastly, I would also like to place reliance on the case of Anil Singh, State of UP versus Anil Singh. It is a 1988 Supreme Court case where it was observed that the public is generally reluctant to come forward to come before the court. It is not proper to reject the case for want of corroboration by independent witness if the case made out is otherwise true and acceptable. It is also experienced that it is the duty of the court to cull out the nuggets of truth from the evidence unless there is reason to believe that inconsistencies of falsehood are so glaring as utterly to destroy confidence in the witness.
Video restore.
Yes, just a last time. It is necessary to remember that a judge does not preside over a criminal trial merely to see that no innocent man is punished. A judge also presides to see that a guilty man does not escape. And with that, if I would like to rest my rebuttals, if I could ask for extension of 1 minute to touch upon the rebuttals of NDPS.
I think that should be sufficient for our purposes. Thank you.
Yes, Your Lordship.
Any rebuttal by the defense?
Yes, Your Lordship. First off, the prosecution had stated that there's no fault of the police, that the police reached late to the crime scene, or there's a certain number of delay in the crime scene. Defense would like to submit that this should not be viewed singularly, this should be cumulatively viewed. The defense had reached the crime scene late, thereby giving a window of people to enter the crime scene and then plant evidence. Moreover, they did not include independent witnesses, neither did they make a complete effort to do so as per the section 104 of the Criminal Procedure Code. Moreover, the case of Yaqub versus the state of Maharashtra states clearly that independent witnesses must be present in paragraph 221 of this judgment. And adding to this point, the police has not searched any witness or themselves or their officials to prove that they did not carry any incriminating evidence for this manner. And if the question of how the hair was planted, the defense would like to bring notice to the court that the Ashu's wife, Sakshi, had also entered the crime scene, and she has reasonable means to get access to Ashu's hair and thereby also implant it. While the defense is not specifically stating that Sakshi did plant the hair, there is a reasonable suspicion with this evidence. The defense would also like to submit that the offenses charged by the prosecution are so grave and the sentences they carry extend to the case to a death penalty. The court must look into this carefully because cases of death penalty are the rarest of the rare, and they must be proved with irrefutable evidence. There is doubt in evidence because the police has failed to include independent witnesses. And apart from the search of the crime scene, the police has not even made the attempt to include independent witnesses, especially for such important recoveries like the recovery of drugs and the recovery of arms. This is stated because the statement of facts in the initial pages states that the police had made an attempt, and upon refusal of these neighbors, they had issued a notice under Section 100, also accusing them of Section 187 of the Indian Penal Code, which is accusing the neighbors of not cooperating with the police. There is no evidence that the police had asked independent witnesses to even join the matter in such important recoveries, and there's no evidence of their refusal and any issuance of a notice under Section 187 in this manner. Moreover, the defense submits that it has conclusively proved that there has been torture in police custody because of the two medical reports taken immediately before the disclosure statement and immediately after the disclosure statement. During the disclosure statement, the accused was in police custody, and these right bruises in the inner thigh is a very sensitive place. The inner thigh is a very sensitive place and well protected by the body itself. And any injury on that part of the body implies that it has been caused by a third person in this manner. Moreover, and hence this disclosure statement should be held inadmissible. The prosecution has also excessively relied on the disclosure statement in proving a loan was present, thereby establishing a motive, in proving that consumption was there, in proving that the accused was present in the house, in proving that the accused had brought cocaine in the house as well. The defense counsel would like to submit that even if the disclosure statement was admissible under Section 27, Section 27 of the Indian Evidence Act deals with subsequent events proven after the disclosure statement. The fact that cocaine was in the crime scene is already known to the police. The fact that the accused had stabbed and shot that the murderer here had stabbed and shot the victims is also known to the police. These evidences cannot be admissible as under Section 27 to begin with in the first place, even if it was supposed to be admissible, which the defense counsel submits it is not, as per the 11-judge bench of State of Bombay versus Katikalu Ogad. The defense submits that the court should duly note the bench size of the Supreme Court judgment to imply how much weightage this rule of law counts on the court. Moreover, the prosecution has again contended that they have satisfied the requirements of Section 65B with respect to the CCTV evidence. The defense would like to quote the section, the relevant part of the section. Section 65B, Clause 4 states that in any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate in doing any of the following things, that is to say, identifying the electronic record containing the statement and describing the manner in which it was produced, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer, and dealing with any matters to which the conditions mentioned in subsection 2 relate. So the conditions in subsection 2 briefly will be speaking about the genuinity of the computer and the output of the evidence as well. This certificate has not been shown in the court of law. And to add on to this, there's no there's no entry in the Malkhana register of the police station, which implies that the pen drive was not deposited in the Malkhana and was in custody of the SHO the entire duration of the investigation. If the chain of custody of such an important piece of evidence is missing, it is highly suspicious that this evidence has been tampered with, and therefore it cannot be admissible in the court of law that this evidence should be used, especially to prove the offenses of such grave and heinous nature. With this, the defense submits all the rebuttals and leaves it to the court to decide the matter.
Thank you. Yes. All of you were excellent, I must say. It was very well done. Thank you very much.
With your lordship's permissions, I would request that all the judges as well as team, we have sent you a Google Meet link, and for the further discussion among the judges for the marking as well as for a feedback for the students, kindly join us on that Google Meet link. And your lordship, it was a great pleasure for all of us to have you with us for this Moot Court competition. I thank you, each and every one of you, for joining us and taking out time from your tight schedules. Thank you very much. And so as this session is going live, we are inviting you for the Google Meet link.
Yes.
Ma'am, if you could let us know where you have sent that Google Meet link.
We are shortly sharing it with you. We will be mailing you. We'll be shortly sending you.
Yeah. All right. Thank you so much, ma'am.
Thank you so much.
Thank you so much, ma'am.
Thank you, sir. Thank you, ma'am.
Thank you. All the best.
Right away, right? This Google Meet link you're sending.
Yes, ma'am. Ma'am, we have just emailed you, and for teams will be joining us later. And in the beginning, three of you can have a discussion among yourselves for the marking as well as for the feedback.
Thank you.
Thank you so much.